Objection!
Your Honor, I object!
And this is the end of this colloquy.
First, about the arbitration. I don't know how much you know the law of the sea. According to the law of the sea, one can go to arbitration on conditions. First, you should have exhausted the negotiations, and that it should be balanced. And the Philippines didn't even tell us they went to arbitration. And the result is very one-sided. And according to the conventional law, arbitration is not final. It can be challenged. And the first country which challenged arbitration is United States about the Nicaragua Bay. And currently, EU still has a case. I think it's Serbia or something, and being challenged. So challenging arbitration is very normal. Thank you.
Minister Manalo, could you address the question raised by Senior Colonel Zhou Bo about whether or not the Philippines, whether there was a promise regarding the removal of the Sierra Madre that the Philippines grounded against Second Thomas Shoal in 1999, and the response to Dr. Wu Shiqun about the recent maritime legislation passed by the Philippines. I believe it was in September 2024.
Yeah, thank you. Before I do that, could I just also have a couple of additional points? First, of the arbitral award. It's clear that the arbitral award of 2016 is legally binding. It's part of international law, and our only hope is that one day China can abide by the arbitral ruling. It would certainly ease tensions. On the issue of the Ayungin, we call it Ayungin Shoal in the Philippines. It's Second Thomas Shoal. There was never any promise to take out the ship. But what we should really take account of is, why is there such a huge presence of Chinese Coast Guard vessels around Ayungin Shoal? I mean, that's the question. That was the reference I made earlier. That shoal is only 70 nautical miles from Philippine territory, yet it's hundreds of miles away from Hainan Island. Why are there so many Chinese Coast Guard ships there? Is it their territory? Anyway, if we follow the UNCLOS or the arbitral award, we are clearly within our rights to patrol that area. But we don't want to pose any threat. We're merely in that area exercising our rights. Then on the Maritime Zones Bill, that is a sovereign act of the Philippines. It's merely aimed to clarify what is in our maritime zone. Because without that clarity, if we ever undertake negotiations, for example, to settle any disputes or claims, you need to have that certainty of what we're talking about. And in fact, in many ways, the definition of our maritime zones will add to peace and stability in the region, rather than leave it uncertain. Without the presence of a maritime zone. And just one other point, if I may, on the issue of the behavior or professional behavior, because as we all know, certainly our services are very professional. But unfortunately, last year in 2023 and 24, the Philippine Coast Guard vessels experienced a number of incidents of ramming, water cannoning, even the use of a laser. Our desire was that perhaps we could behave professionally. If there are any differences, we could use the standard ways of informing other vessels, perhaps, if we feel they're not in the right place here or there. We use the mechanisms provided for by the IMO and not resort to water cannoning or ramming. And I think it's very important that by using these kind of tactics, we only raise tensions. There are other ways that we can reduce tensions, but these are not the way to do it.